with Matt Pappas and Allison Wright, who are joining us today for a Q&A of what employers need to know about the changes related to COVID-19. Matt, if you want to go ahead and get started.
Sure. Today we're here to answer questions regarding the Family First Coronavirus Response Act. Remember that the law was drafted and passed within 2 weeks, not months or years. Unprecedented measures for unprecedented times. This is a cautionary statement that needs to be said at the outset of any such program. What Allie and I would attempt to do is provide information, answers, and then place them on a moving target. Everything we provide is subject to change in a moment's notice due to the disruption that COVID-19 is having on businesses and daily life. The legislation has been introduced in phases. Phase 1, signed March 3rd, provided $8.3 billion in fresh funds for health agencies and testing and for small business loan subsidies. Phase 2, enacted on March 18th and worth about $100 billion, had tax credits for employees offering paid sick leave, an increase to unemployment benefits, and food assistance. The Phase 3 package of roughly $2 trillion completed Friday includes checks to households, bailouts to airlines and other distressed industries, and loans grants for small businesses. There will be a Phase 4, but our focus today is on Phase 2. The Act includes several measures to address the significant impact of COVID-19 on the employment for workers and families, including provisions for emergency paid leave and sick leave, as well as funds to support unemployment compensation programs. We will focus on the leave provisions that begin on April 1st, 2020, and last until December 31st, 2020. These are not permanent benefits, and it's not April Fool's Day. The DOL has been working fast and furious. To illustrate how fast the regs change, new regulations from the DOL came out last Tuesday. The 24th focused on size determination, small businesses, and the effective date of April 1. Then on Friday, telework, intermittent leave, and furloughs was brought into the picture. Then Saturday, 59 Q&As addressed who is covered employer, health providers, and emergency responders. They did so without specifying what had changed from the last version, which allowed us to have to go through and sift through it. Note, the Department of Labor will not be enforcing actions against public or private employers for violations of the Act occurring within 30 days of the enactment of the FFCRA, i.e. March 18th through April 17th, 2020, provided that an employer has made reasonable, good faith efforts to comply with the Act for purposes of non-enforcement position. An employer who is found to have violated the law acts reasonably and in good faith when all of the following facts are present. 1, the employer remedies any and all violations, including by making all affected employees whole as soon as practicable. 2, the violations of the Act were not willful. 3, the department receives a written communication from the employer to comply with the Act in the future. So first, we will go through the 2 leave laws and then respond to your questions that were submitted. First, the Emergency Family and Medical Leave Act. The law is narrower in scope, as also it is known as the Family Care Provision, but longer in duration to its counterpart, the Emergency Paid Sick Leave. The law amends the Family and Medical Leave Act to provide employees of employers with fewer than 500 employees with the ability to take up to 12 weeks of job-protected leave on a partially paid basis under the FMLA if the employee is unable to work or telework due to the need to care for a child due to the closure of a school or place of care or a child care provider is unavailable because of COVID-19 public health emergency. Who's eligible for EFMLA, COVID-19 leave? Any employee who has been employed for at least 30 calendar days by an employer with fewer than 500 employees. There's no minimum hour threshold like the normal FMLA eligibility requirement that an employee have worked at least 1,250 hours over the preceding 12 months. How much must an employee be paid for EFMLA COVID-19 leave? The first 10 days of EFMLA COVID-19 leave is unpaid. An employee can choose but cannot be forced to use vacation or other paid time off during this period, including the emergency paid sick leave. Employers must pay 2/3 of an employee's regular rate of pay after the first 10 days of COVID-19 leave, but such pay is not to exceed $200 a day or $10,000 in the aggregate. Secondly, the Emergency Paid Sick Leave Act. The law includes a new law to provide employees of employers with fewer than 500 employees with emergency paid sick leave. There is no requisite time they need to work for an employer. The benefit is immediate. In addition to the qualified reasons for COVID-19 leave, emergency paid time could be used to the extent that employee is unable to work or telework due to the need for leave because, one, the employee or someone they are caring for is subject to a government quarantine or isolation order related to COVID-19. Now, there are a lot of unknowns about that need for leave. Under the CDC and HHS, the definitions mean isolation is used to separate ill persons who have a communicable disease from those that are healthy. Quarantine is used to separate the restrict the movement of well persons who may have been exposed to a communicable disease to see if they become ill. It's unclear under the current regs whether employees who are neither ill nor restricted due to a possible exposure to the coronavirus, but are unable to work because of orders limiting businesses from operating, are eligible for the 80 hours of paid sick leave. Note, in Illinois, statewide shelter-in-place order may arguably not apply because it's based on prevention rather than exposure. This is changing. 2, the employee or someone they are caring for has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. 3, the employee is experiencing symptoms and seeking a medical diagnosis. 4, the employee is caring for a child due to the closure of a school, place of care, or child care provider is unavailable due to COVID-19 precautions. 5, the employee is experiencing any other substantially similar conditions specified by the Secretary of Health and Human Services in consultation with the Secretary of Treasury and the Secretary of Labor. Full-time employees receive 80 hours of paid sick time, and part-time employees are given paid sick time equivalent to their schedule or normal work hours in an average 2-week period. How much must an employee be paid for emergency sick time? An employee that uses emergency paid sick time for himself or herself must be paid for that time based on the greater of the employee's regular rate or applicable federal, state, and local minimum wage law. Provided, however, that such pay is not to exceed $511 per day and $5,110 in the aggregate for use for the employee himself or herself, and $200 per day and $2,000 in the aggregate for use to care for someone else or for an employee experiencing any other substantially similar conditions as specified by the secretaries mentioned above. DOL has established what appears to be a path for businesses with fewer than 50 workers to limit the review of paid sick leave and family leave obligation to some workers affected by coronavirus. Small businesses can claim an exemption to the new law's requirement that employers offer paid and partially paid leave by the coronavirus-related childcare by determining that it would jeopardize the business's viability. Those businesses are still required to provide up to 2 weeks of sick leave for employees subject to a quarantine or experiencing symptoms associated with COVID-19, the disease caused by the coronavirus. Companies can prove the child care leave requirement put the business in jeopardy in one of 3 ways. An employer must conclude that providing leave would cost more than the company's available revenue, causing the company to cease operation at a minimal capacity. That the loss of workers on leave would be a substantial risk to the company's finances or operations, or there are not enough available and qualified workers to replace employees who are out on leave. DOL stated small businesses should document why they believe they satisfy the criteria, but they don't want the documentation, not yet at least. So we begin the moving target. Allison will start now to go through the moving target of answering the questions. Allison?
Good morning, everyone. Give me just 1 minute while I share the PowerPoint screen to everybody. Matt, can you see that PowerPoint?
I can.
Okay. As Matt just mentioned, things are obviously, and as all of you know, things are changing very quickly. We are in a completely different state of mind, state of business than we were 2 weeks ago. Now, is this a moving target? Yes, but employers and businesses obviously need to make decisions today. We received through the chamber a number of questions. I've grouped them. I think I added a couple. The last ones, I think the cutoff was just about an hour before this presentation. I've added to the PowerPoint here. So some of them are grouped together. We've got a lot of questions about intermittent leave, obviously, and this viability exception that Matt was just talking about. So you'll see some of those are grouped together. And so I'm going to just walk through those. Some of the answers are on some of the slides, but given the short amount of time that we had here, I'll just be talking through most of the responses to that. And when an answer is available on a slide, you'll see that as we'll go through that. So as you see on your screen, question 1, do employees receive a separate bank of 12 weeks in addition to the 12 weeks allotted under FMLA? An example is provided for discussion on this question. An employee was out for 6 weeks in January due to a serious medical condition. Do they only have 6 weeks remaining, or do they have an additional 12? I've read articles with conflicting information. Now, I'm not surprised that you've read articles with conflicting information. A lot of that is because law firms or others are writing articles based on other articles and not the law. So what we need to do is look directly at the law. Let me get to my right slide here. The answer to this question is no. Under the FMLA and the emergency FMLA, an employee is entitled to a total of 12 weeks of leave. Now, I've provided the actual statutory provision here because I think this helps explain that to many people. We've known about traditional FMLA since its enactment. Employers deal with it all the time. This emergency FMLA is something new that we're all trying to work our way through, but it amends the current FMLA statute. It has different qualification requirements, as we know, and Matt touched on those. But I would like everyone to take a look at this slide, and if you see here, what it did is amend the total 12 weeks qualification provision, and it is now the emergency leave is in section F. So you'll see at the top, it says that an employee is entitled to up to 12 weeks. So that means for all of these different reasons. So using the question here, an employee was out for 6 weeks in January due to a serious medical condition. Will they only have 6 weeks remaining? That's correct. Now that's under the EFMLA. This question specifically asks about the Paid Sick Leave Act as well. That is a separate leave entitlement. When somebody takes leave under the Emergency Paid Sick Leave Act, that does not exhaust FMLA necessarily unless they request and are approved emergency FMLA leave at that time. Emergency FMLA leave is only going to apply to a period of time when an employee is taking care of their child because school is out, school is closed, and childcare is unavailable or their daycare is also closed. So under the FMLA, leave because of school care, daycare closures now has been added as a reason. Somebody can take up to the 12 weeks of FMLA leave. And I have provided that provision here so everyone can see that the answer to that question, there's a lot of back and forth about whether it's a separate leave entitlement. It is not, but under the Emergency Paid Sick Leave Act, employees are entitled to leave under that is separate and distinct from the emergency FMLA. Now they work in conjunction with one another. As you'll note, under the emergency FMLA provisions, the first 10 days of that 12-week period of time is unpaid. So the intent of the two acts, they can actually work in unison with one another. If somebody wants to use, let's talk just about a full-time employee, they're entitled to up to 80 hours, 2 full weeks over a 2-week period of time of paid leave under the Emergency Paid Sick Leave Act. Now, they can also be exhausting FMLA, emergency FMLA at that time because those first 10 days are unpaid. So there are going to be different situations depending on what the employee's circumstances are. You could certainly have an employee who uses just emergency paid sick leave for a 2-week period of time, comes back to work or works remotely for a period of time, and then if there's school closures or daycare closures still related to COVID-19, they can qualify for emergency FMLA leave after that time. And that period, that first 10-day period, they won't be able to use the Paid Sick Leave Act to fund that period of time. However, under the emergency FMLA, they are allowed to elect to use any accrued sick leave, vacation time, any accrued PTO that they have to supplement that 10-day unpaid period of time. So you will see situations where the acts will be used together. We're going to see situations where they'll be used separately. But as far as FMLA tracking is concerned, an employee is entitled to 12 weeks total under the FMLA. That includes emergency FMLA provisions as well. So if by the time somebody requests emergency FMLA leave, they have exhausted all of their FMLA leave in its entirety, they will not be entitled to any emergency FMLA leave at that time because they will have exhausted their rights under the law. Question 2. Can employees use EFMLA on an intermittent basis? An example, an employee's husband works Monday through Wednesday, so the employee must be home to care for the children on those days, but she's able to work Thursday through Friday. Another question, we have several hourly employees that are working from home with kids. Oops, sorry about that. Switching through screens here. We have several hourly employees that are working from home with kids, home from school, and daycare. They may not be able to work full-time, but we'll continue to pay them full-time. Can the emergency paid sick leave be taken intermittently? An employee works 30 hours for a particular week and takes 10 hours of leave that week. I believe one of the drafts of the bill did say that it could be taken intermittently, but the final version does not address it. I've heard that the DOL may provide additional guidance soon on this question. What are your thoughts? So in the DOL's guidance, they have provided FAQs, and they treat intermittent leave differently depending on whether an employee is reporting to work at their usual work site or whether they are going to work remotely or telework. As you will see, that is how it is referred to by the DOL. Now, there are different rules that apply depending on how the employee is working, why they are on leave, and where they are working. So let's take a look. I'm going to give you the breakdown of the rules that we know so far. If an employee is working at his or her usual work site, meaning they are continuing to report to one of your facilities, your plants, the regular work site, their office, the employee is required to take paid sick leave in full day increments unless they are taking care of their child because of a school or daycare closure. Now, an employee cannot take paid sick leave intermittently if the leave is they cannot report to work and take it intermittently if it's being taken for certain reasons. If they are subject to a federal, state, or local quarantine or isolation order, if they've been advised by a healthcare provider to self-quarantine due to concerns related to COVID, they're experiencing symptoms and they're seeking a medical diagnosis, if they're caring for somebody who's subject to one of those quarantine orders, or if they're experiencing any other substantially similar condition, which we don't know what that is yet. So once an employee begins taking paid sick leave, unless they're working remotely, the employee has to do so in full day increments until they do one of two things: use the full amount of paid sick leave or no longer have a qualifying reason for the paid sick leave. So once one of those two are triggered, they will no longer be entitled to use of that leave. Now, the distinction between remote work and reporting to work is very important, and it just emphasizes the overall intent to limit the spread of COVID-19. So an employee has far greater restrictions about working intermittently if they are continuing to report to work. They have less restrictions about when they are able to work remotely and do so and use paid sick leave intermittently if they are working remotely. And the reason for that is that if somebody is at home taking care of somebody who has experienced symptoms of COVID-19, has been exposed, or is under a quarantine order, and they're caring for that individual, we don't want them reporting to work right now. We'll talk about the limitations on the availability of tests later on. But these rules, you'll see FAQs 20 and 21. I urge you to take a look at those. And I've summarized, this is what 21, what I was just talking about. This is working at the work site. It shows the different limitations that an employee is going to have as far as being able to take intermittent leave. Now, one major overarching rule regarding intermittent leave under these paid sick leave acts is that an employer has to agree to it. It has to be approved by an employer. That means an employer has the right to say no. Now, here are 5 generalized rules that we know today. You know, we have this moving target theme, but here are 5 rules we know about intermittent leave under these paid sick leave acts today. Yes, they can use intermittent paid sick leave under both of these acts. Does an employer have the right to say no? They do. An employee can use it for any reason if they're working remotely and the employer allows the remote work and they allow the intermittent leave. Now, they can use it to take care of their kids. If they are reporting to their usual work site, they can use remote work. They cannot use intermittent leave if they continue to work at their usual work site and they're using paid sick leave because of one of these 3 reasons. They're under a quarantine or isolation order, they've been advised to stay home by a healthcare professional, or they're caring for an individual who is subject to one of those orders. So this slide provides some of the 5 generalized rules on the use of intermittent leave. And I'm sure there's going to be questions about remote work and intermittent leave. As you'll see when you read through some of the regulations, they actually contemplate an employee using intermittent leave for an hour-and-a-half period of time. Now that can be a significantly a big administrative headache for a number of different reasons. We are working every day, all of our attorneys in our firm are working right now to help move employees to the safest extent possible. And if some of those are being removed to work in remote settings, we do strongly urge you to be tracking hours, not only because of these paid sick leave entitlements that will likely be used at some point by a significant amount of your workforce, unless they are excluded or you are otherwise excluded from the act. So doing things like when they are working on their computer, if that's what they're required to use, looking into application software and things like that. So they're required to be logged in. So you have some sort of tracking as far as that goes, especially if you are going to be looking at a situation where an employee is working remotely and using intermittent leave to do so. Question number 3. Sorry, screens are a little. What happens if an employee is out because they have COVID-19 symptoms, but testing comes back and they actually have influenza, not COVID-19? Can we stop payments since they no longer need to be quarantined? Now, testing is very problematic at this point. I'll say this a couple of different ways. A negative influenza test or a negative respiratory panel does not mean that the person has COVID-19. And a positive respiratory panel does not mean that a person doesn't have COVID-19. Currently, there's no accepted medical guidance which states that an employee who tests positive for influenza could not also have COVID-19. There have been some studies that have already been released that actually say someone can be infected with both. Now, I spoke with Nita Ludwig, the Rock Island County Health Department administrator, this past weekend, just about the current state of testing in the Quad Cities. And she said that all Illinois Department of Public Health labs have very limited access to tests. I'm sure most of you have either heard this, experienced it, or know about it. They have very high standards to get approved to even be tested as a patient. So COVID-19 tests are currently being administered by the public health departments and private labs both. But for the public health departments, they're only being reserved for those that are severely ill or deemed vulnerable. Now on this slide, Nita shared with me the most recent guidance that they were given so that you can see just how limited this standard is. And I appreciate that there's significant urging for test, and everybody is doing everything they can to get as many tests as possible, both in our public and private labs. But currently, under any lab that is run by the Illinois Department of Public Health, these 3 bullet points at the bottom of this letter, this is not the entirety of the letter, just so everybody knows, this is just a snippet from it. Those are the only patients that are going to be approved for testing for COVID-19 at this time. They've got to show severe acute lower respiratory illness, which is pneumonia. They've got to show that they are coming from a cluster of a vulnerable setting. That includes homeless shelters, prisons, jails, correctional settings, nursing homes, things like that. Or they're symptomatic healthcare workers or first responders. They have really prioritized finding out who within our healthcare system may have been exposed or showing symptoms and needs to be tested so they can be removed to limit the spread as it keeps going forward. So I know this wasn't necessarily specifically what the question was about, but to understand exactly how limited the tests are. Now, like I said, patients can probably get them potentially from a private lab, but what we are hearing as of this morning is that that's still being limited to similar standards here. They're being required to jump through multiple hoops, even if they're showing every single classic symptom of COVID-19. If they're not considered especially vulnerable or critically ill, they're not going to get approved for testing. So now I mention that because we're not at a point where we can just say as guidance to employers and businesses, just get your employees tested. If they test positive for influenza, that doesn't mean they don't have COVID-19. If they test negative for influenza, that doesn't mean they do have COVID-19. I'm certainly not a medical expert or a medical professional. You know, as a legal practitioner, we're doing everything we can right now to not only stay on top of the new legal developments and all the laws that seem to be coming out almost by the hour, but we are in a position where we are required to learn as much about as we can about the scientific developments to provide you guys the best guidance that we can. So when we're being asked how to make employment decisions, you know, we are urging everyone to understand the government and healthcare professionals are asking employers to be as flexible as we can in promoting separation and doing everything we can to limit the spread. So here's some basic principles from all of that. If an employee gets a confirmed negative COVID-19 test, you can rely on that. If you have somebody who was able to get one, they're not severely ill. If they are symptomatic, you know, they're probably going to be off for other reasons at this time, but if they get a confirmed negative test, you are able to rely on that. I would require documentation of that, especially if they were symptomatic. It's going to be somewhat unheard of to think of an individual who's getting a test and they're asymptomatic at this time. Now, we just want to be cognizant of the inability to get tested, so be flexible with symptomatic employees and things like that. We're being asked to tell employers to promote flexibility to the extent anybody can, so that those less critically ill aren't overwhelming our healthcare providers. If an employer is requiring strict documentation as a matter of policy at this point to allow for paid sick leave, we are going to be sending waves of symptomatic people into doctors' offices and clinics. That is not what they want, and that is not what's going to help limit the spread. It's going to overwhelm the system and potentially even just spread within those offices. So consider where you can how to be flexible. But stated briefly, if you get a confirmed negative test, you're allowed to rely on that. I would not rely on the proof of a positive test for something else like influenza to be exclusionary and find that as a confirmation that someone doesn't have COVID-19, just given the current lack of testing one way or the other. Question 4, is there compensation for employees laid off from church staff as a result of COVID-19 Illinois closures? The church is closed and several staff work from home and others are not working. Obviously unemployment, because churches and religious organizations are exempt. Employees of churches and church affiliated schools aren't going to be receiving unemployment, but there's no similar exclusion under the EFMLA or the Paid Sick Leave Act. So those employees, if they're working at home, you'll continue to pay them their regular wages, obviously. But if they are seeking leave under the federal act and they otherwise meet the qualifications for that, there's no exclusion for the church under that statute. Question 5, does a company owe union benefits as part of the EFMLA if not required by their CBAs? And are union benefits not payable directly to the employee but to the union due as part of the EFMLA? Now, if I'm understanding this question correctly, the first one, I think the answer, if I'm understanding it correctly, the answer is yes. And employees' benefits or entitlements under a collective bargaining agreement are going to be wholly distinct from an employee's rights under the Families First Coronavirus Response Act, which includes the emergency paid and the emergency FMLA leave. A CBA won't be able to limit those rights, but they, under explicit provisions in a CBA, which would pretty much be unheard of, they can't, unless it's explicitly provided in there, a company can't require an employee to use federal emergency leave instead of other leave entitlements provided by the CBA. So that yes, they will be entitled to the paid sick leave. Most CBAs are going to provide language that simply mirrors the FMLA or provides that those statutory entitlements are also available to their membership. So unless you're concerned about a specific provision or they might be entitled to greater benefits, you need to look specifically at what your CBA language says there. So the benefits that are going to be paid under the Families First Coronavirus Response Act are paid directly from the employer to the employee, and private employers would then be entitled to that tax credit reimbursement for the amount of the leave that's provided. Question 6, what will companies do who are under 500 and under 50 and still can't afford these types of payments? Now, the Coronavirus Response Act only provides a mechanism of exemption for companies with 50 or fewer employees. And Matt talked about the different standards for that, and I have a slide, I'll show you the breakdown of how that works. Companies that fall within the 51 to 499 employee range are not going to be able to apply for that viability exemption under the current state of the law. Therefore, you're going to need to review your workforce and prepare for utilization of this leave starting April 1st. Companies will be refunded in the form of a tax credit for the paid leave. I would use air quotes around the word refund because you really are just holding back payroll taxes and as a means to pay yourself. Now, the refund is 100% of the paid leave provided. If a company is concerned about that providing that leave, even with the available tax credit, is going to jeopardize the viability of your company, and you are between that, you're above 51 but below 500, so the act applies to you, then you're going to need to make necessary workforce adjustments to the extent that you can. These are difficult times, lots of difficult decisions are being made. We've been on the phone fairly constantly with clients working through furloughs and layoffs and other types of arrangements. You could diminish hours, adjust schedule. There's lots of options, but it really depends what your workforce looks like. If you lay off some of your workforce, then they're not going to be entitled to paid leave under the Families First Coronavirus Response Act under the current state of the guidelines, because they wouldn't be able to show they'd otherwise be entitled to working hours at that time, except for a COVID-19 related reason. Now that may be expanded. The guidelines may stretch a little bit further and try to reach into closures and things like that. But at the current time, if somebody is laid off, they're not going to get the benefit of these paid leave acts. Employees who are laid off prior to the act's effective date, this coming Wednesday, won't have any rights under the act. So there's no one-size-fits-all response to this question. Depending on the specific composition of your workforce and the demands of your production or the demands of your specific business, different responses are going to be required by different companies. Now, question 7, I have an additional question pertaining to the extended FMLA leave. There will be some instances where a daycare will have closed, but there will be another parent at home who could take care of the children. How do we handle when both parents want to stay home and they do not have a medical quarantine to keep them both home? This question is fairly loaded. For an employee to take leave under the EFMLA in response to their child's school closure, the employee has to show there aren't other options available and that they must stay home with the child. What specifically is required for that, we don't know yet. We don't necessarily know what they're going to need to prove, and what documentation is going to be required to show. But I'll talk a little bit about types of documentation I would expect to see. If an employee has another parent at home who's able to provide child care and the employee can't show that they must also stay home, the employee shouldn't be granted the leave under the current state of the law. But again, a lot of this is going to depend on how we're getting the information and how we're verifying that information that is coming to be known by you. So do I expect this to be hard to administer, especially when both parents are at home, where there's 2 caretakers at home? Sure. Will we always know if an employee has other options available? Are we going to know if their spouse is at home working remotely, if they're available to take care of the children, if they're sick or exhibiting symptoms? No. Now, it could be different if both spouses are employed by the same business. Then you may have some additional information to be able to confirm one way or the other. But if they're not both employed at the same company, it's going to be difficult for employers to confirm that one spouse is not working or is at home working but unavailable to help with the children, as opposed to maybe also being off on paid leave. So do I expect that there will potentially be some abuse in these situations? Potentially. Overarching theme here is that if 2 people are outside of work environments, they are potentially helping limit the spread. We don't necessarily know exactly how to limit the abuse unless you're looking at a specific situation at this time. So are there things you could do to help curb abuse now? We've been working on remote work policies and agreements. We've developed leave request forms that are consistent with the Coronavirus Response Act. So one option that I would include is a statement on either the request for leave or signed agreement for remote work that really confirms the employee's basis for the request. So in the instance of needing to stay home because there's no other option for childcare, you could require them to attest to a statement that confirms exactly that. It puts the burden on them, but at the same time, if we do get substantial information or verified information that there is some sort of abuse, you do have a situation then where an employee has lied to you, and you can address that like you usually would. Question 8, are city municipalities allowed to take the tax credit? At this time, public employers aren't entitled to the tax credit. I do recommend that you track every dollar spent on paid leave under the Coronavirus Response Act, just as if you were going to seek and use the tax credit, because there's a lot of different packages of relief and proposals that are being floated at this time, and they're working towards reimbursing government bodies in a different way. So I would track it as if you were going to be reimbursed, but no, at this time, that mechanism is not an option. Question 9, an employee can find replacement daycare for 2 days per week, but not all 5. Are they entitled to receive proportionate income and insurance benefits from the employer? Now, I'd like to give you guys quick yes and no answers, but unfortunately there are other laws out there besides the one that we're talking about today, and this one implicates the FLSA and state wage and hour issues. You can't answer it without giving some consideration to those laws. So in short, it depends whether they're classified as exempt or non-exempt. If they are exempt, and you reduce their salary and benefits commensurate with their new schedule, then yes, that would be proportionate. So here's some quick overview of some of the rules that we do know. An employee is only allowed to use intermittent emergency FMLA leave if the employer allows them to. So if like I said before, I think I showed you DOL FAQs number 20 through 21 and 22 talk about intermittent leave. And 22 says intermittent leave is allowed, but only with the employer's permission. There's no requirement that the employer have to agree to that, like we talked about before. Now, if an employee is hourly, you're going to pay them for the time that they work, but the analysis gets trickier, as everybody knows, if they're salaried and exempt employees. Without modifying their pay, if they perform any work in a given week, they're going to be entitled to their full pay for the week under the FLSA. So if an employee like the one in this example wants to take intermittent leave and only work 2 out of the 5 days, you're going to want to consider reducing the employee's salary proportionate with the work schedule reduction. In the limited amount of time we have today, I'm not going to go through the entire FLSA analysis, but I do recommend you closely look at that for your workforce. If you're looking at ways to scale back, and if you are making those types of modifications, be very careful with salaried workers and looking to make sure, because the one thing that is most important is making sure that they meet that minimum salary threshold, even with the reduction. Otherwise, we're going to have a trickling effect where you're going to be losing that FLSA exemption altogether. Question 10, will the employer be reimbursed for this person's insurance premiums paid while on approved leave for a proportionate time? Based on the current guidance, our answer to this answer to this question is yes. It does seem, based on the way the guidance is written now, that employers are going to receive 100% reimbursement for paid leave, including health insurance costs. So you can, there's more information from the DOL about the credit reimbursement program. The 200 or the 511 per day maximum tax credit is still going to apply here. So that is going to be in play as well. So don't forget to make sure you're considering those maximums. Let's check on time here. Is it safe to assume it is broken down by hours and not limited to use 80 hours in 2 weeks? The answer to that question is no. The Emergency Paid Sick Leave Act requires that paid sick leave be paid up to 80 hours over a 2-week period of time. So once they start the leave for full-time employees, you have a 2-week time clock that you are working with there. Larger employers are required to pay up to 80 hours of paid sick leave under FMLA expansion. We presently have a paid sick leave policy. Is the employer required to use the company benefit plan sick leave hours first, and the remaining hours required to cover the entire 80 hours would be considered the FMLA expansion. In that case, only the hours actually covered would be exempt from the employer's Social Security taxes. So here, under both paid sick leave acts, the EFMLA and the Paid Sick Leave Act, you cannot require an employee to exhaust other entitlements before they are allowed to use either of those. If they qualify for FMLA, they're going to qualify, and then that leave will start. But under the Emergency Paid Sick Leave Act, Section E2B specifically prohibits an employer from requiring any employee to use other paid leave provided before they can use that. So it's an automatic entitlement. It's going to start on April 1st that they'll be able to use that. Question this is the specific provision about the Emergency FMLA, about Mail Act. What is a substantially similar condition as specified by the Secretary of Health and Human Services? The situation is covered by 2/3. We don't have the answer to this question yet because it doesn't exist. I would watch for guidance on this, but I would assume there's really no substantially similar condition. It's kind of a catch-all provision, but it doesn't have any play currently with what we know about COVID-19. What insurance premiums are reimbursed for during approved leave? Dental, life, disability qualify. There's no direct guidance on this right now, but the reimbursement is intended to be a dollar for dollar reimbursement. So everything can be included under the current state of the law until we see further guidance on that. I would operate for that dollar for dollar intent that's been expressed. If an employee has a doctor's note taking them off work because of an ongoing medical condition or concern, but does not have the virus, nor do they live with or care for anyone who has it, are you required to pay them under this law? In other words, they're simply trying to avoid it. Now, the answer to this is it depends. It would only be under the Emergency Paid Sick Leave Act that we're talking about here, because as the example explains, they're not staying home to care for a child because of a school closure or daycare, so the EFMLA is out. If an employee brings you a note that says they've been directed by their doctor to self-quarantine because their ongoing medical condition places them at higher risk of adverse consequences if they're infected by COVID-19, then there's a good chance they're going to qualify as an employee who's been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19. There is no direct guidance on this at this time, but if the guidance does specifically address this, which we've submitted information to the DOL, seeking guidance on that specific situation. But if that is the way, an employer would be required to pay the employee if the doctor's note specifically recommends that the employee self-quarantine due to COVID-19. The note should specifically state that the risk of COVID-19 is the justification for the self-quarantine recommendation. I would also just briefly note that you're going to want to look and consider, obviously, the ADA when you start seeing requests like this, because I think they will be much more common in the days coming ahead. I don't know if I can keep going. A couple more, we'll do one more question. I think 16 is a pretty easy one. Large percentage of our work staff are high school age, no minimum age under the Paid Sick Leave Act. So any of your employees are going to qualify if they otherwise meet the requirements of that. Now the viability exemption, we got a lot of questions about this. I'll scroll through so you guys can see. Small businesses, when do we expect to see information about the viability? And Matt talked about these. So here, this is the three. I have 2 slides that explain that. A small business is going to be exempt if the employer employs fewer than 50, if the leave is requested because the child's school is closed or the child care provider is unavailable due to COVID-19 related reasons. And then the last element is that an authorized officer of the business has to determine that at least one of these 3 conditions on this next slide are met. And Matt walked through those. They're available on this slide, so I'm not going to read through each of those. Documentation has not yet been released. We're expecting IRS forms. There's a joint statement from the IRS and the DOL explaining what guidelines are going to be forthcoming. I do expect that those will be released this week. There's going to be specific forms that we expect everyone will be using for that. So, different types of documentation are going to be required depending on the type of business that you're looking at. If a worker is home for school closure and for any other reason, does the time count on the EFMLA clock or not? Now, if an employee has been on an employer's payroll for 30 days, that's a qualification for EFMLA, and they need to stay home to care for their child who's age 17 years old or younger, the employee is going to be able to request emergency FMLA leave, unless for some other reason they don't qualify. If your business is exempt or they're a healthcare worker, healthcare provider, or a first responder. So an employer can't require an employee to take emergency FMLA any more than we can require an employee to take traditional FMLA leave. I'm sure you've all had situations where you send the notice and you even strongly urge an employee to take this protected leave, but they don't. So you can't require them to take it, but if they're home and they meet the requirements and they request to take that leave, then yes, the EFMLA clock is going to start for those situations. If a business is more generous than what is required, will we still be in compliance, and would there be any negative consequences for being more generous in those situations? You guys can read the full question here. The emergency FMLA requires an employer to pay an employee in an amount that's not less than 2/3 of an employee's regular rate of pay. You're not going to be penalized for paying them more than that. I would just note that you'll be subject to the overall daily cap. So more than $200 a day, that's the cap for that, and $10,000 is the max for the emergency paid FMLA leave altogether. Question 20, what type of documentation should the employer maintain in order to claim the tax credits? What will the employer have to submit? Now the IRS has stated it's going to release guidance on how to handle these tax credits this week. So you'll be able to use different forms. This next slide, this is their joint statement on this issue. This talks about how it's going to work. You know, they call it a refund, but you're really reallocating those payroll that you'd otherwise be depositing with to pay taxes for payroll taxes. You'll just be reallocating how you use those funds to fund the leave. So that's the main 3 points from the joint statement. Sorry, I'm going fast. I'm trying to get through as many as we can. Would the owner on the payroll qualify for the Paid Sick Leave Act tax deduction if they are a regular salaried employee on the payroll? Answer is yes. If all the requirements for the Emergency Paid Sick Leave Act are met and they take leave for that, the company can include that salary in the tax credit. And just remember, it's going to be subject to those limitations. I don't know how much they're paid. It's $511 for a full-time employee per day, up to $5,110 for a 10-day period. $200 a day for part-time, up to $2,000. If it's the owner and they're working full-time, it's going to be those $511, $5,110 10-day period caps. How do employment benefits work with paid sick leave under the Paid Sick Leave Act? Can someone get the sick leave and unemployment benefits in the same week? There's a lot changing with unemployment. So this question kind of perfectly highlights the types of strategies companies are exploring because they're trying to take care of their employees either through their own funding or through availability of unemployment options. So yes, an employer can provide 2 weeks of paid sick leave so long as the employees qualify for the leave, obviously, and enjoy the tax credit refund for that payroll, and then furlough employees. Employees can get unemployment for both a reduction in hours and a layoff. There's emergency guidance as far as unemployment is concerned that may or may not qualify them for furloughs specifically under COVID-19. So receipt of paid sick leave entitlement could impact their unemployment in a given week. But, you know, I would recommend you run through various scenarios that you're going to face, that your employees are going to face when you decide when you're going to furlough, when you're going to lay off, and different types of arrangements that are going to work for your workforce. Our understanding is that we are required to give the paid sick leave to all employees. Do we as employers give this to employees up front, or do the employees have to come to the employer and tell them that they are requesting it? Employees have to request this leave. So we've spent much of the last week drafting leave policies that are consistent with the Coronavirus Response Act, and it incorporates both of these paid leaves. So the emergency paid sick leave and the EFMLA. So if you have a policy in place, great. If you don't, I would recommend that you get one, especially because there's certain discretionary things that you can exclude if you're that type of an employer. But outside of that, you are going to want to have a form or a process for that, because a lot of people are off site at this time during closures and things like that. You could set up an online submission format for your company website. You could also just have it as easy as a form that needs to be submitted by email. Whatever format you choose, we've been recommending to clients that you don't require face-to-face interactions or hand delivery through this process, just to limit the concentration of people in anybody's office. It's not fair for HR professionals to be kind of on the forefront of that. If we say to them, here's our new policy, here's how they request the leave, and guess what, you get to meet with them before you approve it. I don't recommend that. I would go electronic as far as that's concerned. The additional $600 unemployment benefit seems too good to be true. There are not a whole lot of strings attached as far as this is currently written. The additional $600 is going to be a windfall, as many have said, for employees who otherwise don't make that much. So yes, it's an absolute $600 entitlement as currently written under the guidelines, whether you're part-time or full-time. And the last question, I apologize, I'm going so fast. If an employer has made wage payments, I'm assuming that means paid leave payments, to an employee prior to April 1, are these payments eligible for the tax credit? The answer to that is no. The paid leave under the emergency paid sick leave or the emergency FMLA laws cannot be applied retroactively. There won't be tax credits available for the leave provided, even if all the qualifications are met prior to April 1. You may, however, be entitled to other relief or reimbursement through the CARES Act and other state and local relief efforts and loan programs, including those that are going to forgive loans. So the CARES Act is obviously not the topic of today's presentation, but we've been working through that, and it does provide reimbursement mechanisms for different payrolls that retroactively dates back to January 1. So we are seeing some mirroring of that in some of the state and local relief that's being allowed and provided as well. And that is the last of the questions that I received for those. Tyler?
I've answered some of the ones that have come online as well, but other than that, I think that's the day.
Perfect. Great. Well, thank you everybody for joining us again today. Thank you to Matt and Allie for joining us and answering a lot of really good questions. Again, our webinar is going to be recorded and is going to be available on our website, quadcitieschamber.com. We also have a lot of other COVID-19 related topics on there as well. We're planning to do some more of these webinars here in the near future, so be sure to but again, want to thank Allie and Matt and all of our people that are joining us today. Have a great rest of your day.
Thank you.
Thank you, everyone.